Welcome. My name is Harold Furchtgott-Roth, and I'll be your moderator today here at the Hudson Institute and the Center for the Economics of the Internet. Today, we're going to be discussing an important issue at the Federal Trade Commission, which is the use of Section 13B for the Federal Trade Commission to effectively seize assets of unsuspecting companies that may or may not have done anything wrong. To discuss this issue, we have with us today Caleb Kruckenberg of the Pacific Legal Foundation, in my view, probably the leading expert on how 13B is being used and potentially misused by the Federal Trade Commission. Mr. Kruckenberg has written extensively about this matter, and we're very much looking forward to hearing his presentation and learning more about Section 13B and the Federal Trade Commission. Mr. Kruckenberg.
Well, thank you very much for having me. Law enforcement should follow the law. That seems pretty simple. But unfortunately, it doesn't always work out that way. And it certainly doesn't work out that way with the FTC, the Federal Trade Commission. When incoming FTC chair Lina Khan sat down with New York Magazine in October of last year, she said she was pretty blunt about her agenda for the agency. She criticized her predecessors at the commission, and she said that her biggest worry moving forward was, quote, the existential stakes of underreaching and, of course, neutering the tools available to the agency to, in her mind, fight businesses that threaten our economy, our society, and our democracy. She was also asked if she worried about overreaching. And she said, quote, when identifying the top 10 threats to this agency, that's not on the list. Well, it turns out that Chair Khan really wasn't kidding. In recent months, the FTC has quietly been ignoring a recent Supreme Court decision that was unanimous. Apparently because in the agency's mind, the ends justify the means. But as a law enforcement agency, that is, to say the least, very troubling. Now, the FTC usually has enforcement power over unfair or deceptive business practices. And that's really the focus of our conversation today. And there's two basic ways they can go about it. They can do administrative proceedings, or they can file a lawsuit directly in federal court. And that's using Section 13B of the Federal Trade Commission Act. Now, these are somewhat unique lawsuits because there's a process called an ex parte injunction, and that's going to be a lot of our conversation today, where the FTC goes to a federal judge in secret. The defense, the defendant, the company at issue doesn't have any chance to defend itself. It doesn't even know about this. And the FTC gets an order from the federal court freezing the company's assets, seizing the company's assets, and appointing a third-party receiver to run the company. Now, the first time these companies find out about these lawsuits usually is when the receiver shows up with a court order saying, this is my company now. Now you have to defend yourself. And from that start of the litigation, the company then has to ask the court for permission to pay lawyers to defend itself. And almost unsurprisingly, almost all of these companies settle. And they enter what are called consent orders, which is an agreement with the FTC to settle the charges against them. And it usually involves substantial penalties, financial penalties. Now, the FTC has always had very limited authority, though, on what kind of penalties it can get from a company. And this was Congress's effort, at least, to balance this extraordinary power of these ex parte injunctions. Now, Section 13 of the FTC Act says that in this process, the only thing the agency is allowed to get against a company is a, quote, permanent injunction after proper proof that the company has violated part of the statute, these prohibitions on unfair conduct. But for decades, the FTC has insisted, and courts have accepted, that the words permanent injunction actually allows the agency to get financial penalties and what they called disgorgement of ill-gotten gains. Now, disgorgement is this idea that if somebody takes money they're not entitled to, well, they have to disgorge it back. They have to give it back to the person they took it from. Now, as a matter of equity, which is something that has been part of our law for a very long time, this is only supposed to be paying back what you got that you shouldn't have, paying back what you stole, essentially. But in practice, this was used to allow orders that exceeded a company's net proceeds. They were gross receipts that a company ever took in its entire existence. They significantly exceeded any kind of money taken from a company or a customer based on misconduct. And they weren't paid back to the customers or the consumers. They were paid to the United States Treasury. In essence, the agency said, we will take all the money you've ever earned as a company, even if it didn't relate to any misconduct, and we, the government, will keep it. In one case, the Seventh Circuit Court of Appeals said the FTC only needed to pay this money to harmed consumers as a matter of grace. It's like if I stole your car and I had to return it to the government, not you. Now, in practice, these became huge fines, and they exerted tremendous leverage on companies facing enforcement actions, particularly when they were subject to ex parte injunctions. And it was huge business. The FTC generated billions of dollars in disgorgement awards annually, but very little of this went to consumers. But in April of last year, a unanimous Supreme Court held that disgorgement, as it had been used by the FTC, and in that case, it was a $1.27 billion judgment, was unlawful. And according to the court, the agency never had the power to demand these kind of penalties. Now, just to contrast how large that one award was in the Supreme Court case, it was more than 3 times the total amount that the agency returned to customers directly in all of its cases in 2021. And the practice was very clear. The FTC was extorting money that it couldn't lawfully extort, couldn't lawfully take from these companies. And the court was very clear. It said, Section 13B of the Act did not authorize the commission to seek and a court to award equitable relief, such as restitution or disgorgement. Now, this left the FTC scrambling. Now, in a press release, the FTC's director of the Bureau of Competition called the decision deeply disappointing and claimed that the court had stripped consumers of relief and called for congressional action to reinstate the FTC's authority. Of course, keep in mind, the FTC never had this so-called authority, and the money didn't go to consumers. This really was a PR effort by the agency. But rather than just complain about it, my colleague John Kirchhoff at Pacific Legal Foundation and I discovered back in December that the FTC had simply decided to ignore this Supreme Court decision. And they had entered, without much fanfare, several consent orders, several settlements with companies that included disgorgement awards payable to the United States Treasury, even though the Supreme Court said this was unlawful. For example, in December, the FTC obtained an order for almost $34 million against a credit report company and its principal for what it called consumer relief. But in the settlement, it said, quote, any money not used for such relief is to be deposited in the US Treasury as disgorgement. Seems the FTC and the company that was the defendant in that case are agreeing to the penalties that the Supreme Court said were unlawful. This isn't an isolated practice. It's happened a number of times in the past few months, including just a few weeks ago. But even though this is illegal, even though the Supreme Court said the agency can't do this, if you enter a settlement, that means there's really no judicial oversight. That means you've agreed to it, and the FTC agreed to it. And so even though the Supreme Court said this is unlawful, very few courts are going to reach out and say, oh, I'm not going to allow this, or I'm going to overrule this, because the parties have agreed to it. What that means is that the FTC is allowed to ignore the Supreme Court's order. They're allowed to ignore the supremacy of the court and continue doing this unlawful practice. I have several goals for today's topic, and the first is just to talk about what's happening and let people know that the agency is defying the Supreme Court. But I also want to talk about why companies in this position would agree to something like this. Why would a company that's facing enforcement agree to pay an award that it presumably its lawyers at least know is unlawful? And I want to also talk about, hopefully, some solutions to this problem. The FTC claims to care about unfairness. That's the statute that they are supposed to enforce. But they don't seem to think that they're bound by the same concept. They engage in what I believe is extremely unfair conduct. We cannot allow the agency to cheat and openly defy the Supreme Court, particularly just because it thinks no one will notice. If the agency won't stop, then we have to convince the other branches, Congress, and in my case, the courts, to intervene. And with those opening remarks, I want to open up some conversations with Harold about some of the processes and some of the specifics that the FTC uses in this process.
Well, thank you. Thank you very much. That's a very powerful and candidly very frightening presentation you just made about what's happening with Section 13B and the Federal Trade Commission. Let's follow up a little bit on what the FTC has been doing recently. And so if a party enters into an agreement with a federal agency, even if they have a gun pointed at their head that says, unless you agree to this, you're completely wiped out. They're doing this in essence under duress. They have no recourse to go back in to get restitution, even after the Supreme Court found unanimously that the practice of the FTC in interpreting 13B was unlawful. Am I interpreting that correctly?
Well, that's certainly the agency's position. And I guess probably the place to start is how these consent orders are entered. It usually, I wouldn't call this a criminal proceeding, but if I analogize to a criminal proceeding, when you're subject to government enforcement or prosecution, the only way you're allowed to settle that kind of a case is you have to go into court, you have to face the judge, and the judge will ask you a very extensive series of questions to make sure that this is really what you want to do and you understand the process. And with the settlement with an agency like the FTC, even though in practice they have the power, or they think they have the power, to take your entire livelihood and sometimes even ban you from an industry, all the judge does to approve one of these settlements is looks to see if you've signed it. The FTC gives you a piece of paper, You sign it, you file it with the court, and the court approves it. And that's usually the only review the judge is going to give. And that, but as we've seen, that includes what are unlawful conditions or conditions that the Supreme Court has said are not permitted. I think it is an open question, and it's a very interesting question, what companies should do or could do if they've already entered into these settlements before the Supreme Court decision. So this decision in April of last year was AMG Capital versus FTC. And I'm actually representing a client, and we will be filing a lawsuit relatively soon to try to reopen a case where my client has entered one of these settlements, and it included a substantial disgorgement award. And the argument is pretty simple. It says, well, the court said you can't do that. How could we agree to something that is illegal? So far, the courts have not been willing to reopen those cases, but I think it is a worthwhile venture, and I think the courts should reopen them.
There certainly are other instances where courts, where the Supreme Court has found some law to be unlawful, and parties that had been adversely affected by the enforcement of that law in the past could go back and seek some form of restitution. So I assume this isn't a novel idea, is it?
No, it's not, and it goes back. I mean, it goes back decades, and the Supreme Court has said in different contexts, they've said if there's a substantial change in the law, sometimes that's enough to warrant reopening a case. And certainly, if we're talking about the principal enforcement mechanism for the agency, the principal ability for them to get a fine against you, that's a substantial change in the law, because the reason that this Section 13B authority developed in the first place is the agency doesn't have power to get fines. Lots of agencies can, like the SEC or the Department of Labor even, but the Federal Trade Commission doesn't have that authority. So they had to come up with some other authority. If you take that away, that's all of their power. That's all of their bargaining position.
Although 13B, the language of that section gives the commission the authority to seek an injunction against unfair practices, that would seem like a fairly powerful tool. If in fact there is an unfair practice, why not just have the federal agency stop the practice? Why isn't that sufficient?
Well, so I think probably to answer that question, it's good to go back a little bit to the two mechanisms that the FTC has and the way that I think Congress envisioned the agency operating. So originally, I think it was in 1914, Congress told the agency, you can start administrative proceedings, and that is your sole function. You are allowed to, as a commission, vote to decide you want to investigate a company or file a complaint against a company. Then you have to have a hearing. Then you have to make a determination as an agency that the company has done something wrong. And if you are successful with all of that, if you go through the entire process, the company or the agency can go to a federal court to enforce an order against a company to say, you can't do this practice anymore. In the 1970s, Congress thought, well, we need an emergency alternative. And that's where Section 13B came from. But it was seen as an emergency. And the statute says in a proper case, the agency, if it thinks there's an imminent threat to consumers, can go to a federal court and only get an injunction. It doesn't say anything else. It doesn't say anything about fines or anything else. And the idea, at least as I read the statute, is that the agency should be able, if there's a really, really serious case and they think that consumers are actively being harmed, they can go to a court to stop that practice while they go through the administrative process. But in practice, what happened is they started saying every case is a 13B case. we're going to go through that process. And then the courts allowed them, instead of just getting an injunction, they got ex parte injunctions. They were allowed to get sealed injunctions against a company before the company even knew about it. And so instead of using this emergency power in exceptional cases, just became the norm. And that's how the ex parte process started. And then while they were there, they just said, hey, give us money too. And I think in that situation, companies had an extremely difficult time fighting back.
Presumably the federal district court judges that are issuing, that receive the ex parte hearing are aware of the Supreme Court case. Why are the federal district court judges not saying I'm not allowed to do this?
Well, that's a very good question. And I would expect a judge to not be willing to sign it. So far, the judges have been willing to sign it. And frankly, in some of these cases, I have seen entries in the docket where the FTC has, because all of these cases have been around for a while. And so in the original complaints or in the original injunctions, the agency will say, we want disgorgement under Section 13B. I've seen in some of these cases, the agency has filed a notice with the court saying, the Supreme Court said we can't get disgorgement anymore. We're going to take that out of our complaint. And then 6 weeks later, entered a settlement with that same order, that same award. The only sort of justification I can give for it, I can ascribe to the agency. Chair Khan issued a statement in another case on another issue, but she said essentially that she thinks that parties can settle to things that aren't necessarily allowed under the law. And I respectfully disagree with her. I think the Supreme Court has said otherwise a number of times, but I think that's her position.
Let's drill down a little bit on just the process of how we even get to a 13B. Is it the case that there is a formal hearing or investigation going on at the FTC before a 13B case is filed with the court, or are these cases filed before there is a formal hearing at the FTC?
Well, that's unfortunately why they use this alternative process. So the original administrative process, you have to convince the commission to file the complaint in the first place. And the Federal Trade Commission is a bipartisan commission. It's an independent agency. So there's presumably some sort of check on their authority or their willingness to push boundaries. But with Section 13B, it never goes to the commission. You don't have to have commission approval. You have to have an agency attorney. And unfortunately, one of the things the statute says is that the commission or its designee, in many cases, that's just an FTC employee, can initiate the process. And so in practice, what we see is we see individual offices, individual bureaus just deciding we're going to file this case. And then they go to federal court. And all they have to do at that point is convince a judge without hearing from the other side that it is likely that the company has violated one or more of the rules that the FTC is allowed to enforce. And that is a pretty low burden of proof.
Caleb, this is frankly pretty shocking. Let me see if I understand this. The designee of the commission can be someone who does not even inform the 5 commissioners that they're going to go to court, or even one of the commissioners. They can just go off and go to court.
There's certainly no statutory impediment. And I'm sure if you ask the agency, they'll say, oh, of course the commission is aware of what we're doing. our cases become public ultimately. So obviously the commission is aware of it. But no, the normal process is they do whatever the bureaus do, and I'm sure they eventually report their cases to the commission. There is no sign off, there's no requirement that the agency sit as a commission and decide to bring these cases.
Do you suspect that at least the chair of the commission is aware of it? Someone has to authorize going to court. I'm deeply troubled by the idea that there is no oversight of that decision, or maybe it's just the bureau chief. Someone's got to say yes, you can go to court.
Well, and the agency may have their own internal practice and their own internal approval process, but that doesn't mean that there's I think a significant difference between a bureau chief or a bureau supervisor or litigation supervisor, some employee of the agency, presumably a career employee, authorizing an individual lawsuit versus the commission or even a commissioner. I mean, as Chair Khan's statements, I think, would illustrate, she is a partisan appointee. She's a very partisan person. She's given a lot of speeches about that and about her agenda. I think even if it was just one commissioner could approve individual lawsuits, I think that would be bad enough because there's a lot of dissent in the commission. But there's not even that requirement. I mean, it's enough that an employee of the agency makes the decision they want to file the lawsuit.
Does the FTC go to court on its own, or does the Department of Justice in any way represent the FTC in court, or how does that work?
So the FTC has its own litigation attorneys, and they're the FTC's enforcement bureau. And really, they're the ones who are making the decision on whether to move forward with a case. The FTC can make referrals to the US Department of Justice in criminal cases, but unlike the normal complaint process, to make a referral to the Department of Justice, they actually have to get approval. They have to go to the commission and get approval for a referral. And so that is very rarely exercised. It's almost exclusively their in-house lawyers are filing these cases in federal court.
Let's do a little exercise, and let's stipulate there is a company that's engaged in some wrongful conduct of some sort, some deceptive trade practice. How does that come to the attention of the commission staff? Is it something that is reported by local law enforcement? Is it something that's reported by federal law enforcement? Is it something that the FTC staff sort of figures out on their own without any law enforcement activity? Or how does this come to the attention of the FTC staff?
Well, there are a lot of different ways it can come to their attention. I mean, as with any law enforcement agency, it relies on a lot of different sources, but the agency has an investigations bureau. They are constantly going out looking for potential violations. But the FTC, I think, even more so than a lot of other agencies, relies heavily on tips, on reports, on complaints. Sometimes these are consumer complaints, just as often that they're competitor complaints. And I think that's a very common practice. In certain industries where the agency is likely to engage in enforcement. And what I mean by that, there are a lot of rules concerning advertising and credit reporting, and subscription services and things like that. So there's a lot of companies, I think, where there's very active enforcement. I don't think it's uncommon for competitors to file complaints against each other, to go to the agency and say, this other company, I think their advertising practices are unlawful. You should go check them out. And then a lot of times that'll happen because the FTC, I think, like a lot of agencies, I don't want to call them lazy, but I think what they do is they look for cases they think they can absolutely win. That is a much more important consideration for them than, in my opinion, than consumer safety or protecting the public or taking important action. I think it's really about, for them, we want to win a case. We want to get a lot of money from a company.
Well, you've just raised two issues. One is winning a case, which must mean you have some facts that are helpful and suggestive you might win. And the other is that the target company actually has some assets worth seizing, that they're not just an empty, failing company. So the FTC must require a fair amount of staff effort and time to determine that they have the fact pattern, and separately gather enough information to determine that this target actually has some assets worth seizing. Or am I missing?
Well, I think I would agree with you on the second part of that. I think what the agency is trying to do, and again, I think part of this is the very lenient standard of proof that they have to prove, because they just have to go to the court and say there's reason to believe there's some sort of ongoing violation. And I'd also say that a lot of these unfair practice rules, they're very uncertain. And that's what the rule says: you can't engage in unfairness. And I think in practice, what is unfair is really often in the eye of the beholder. So what the agency will do is they will accumulate evidence of a practice that they think is at least arguably unfair. And what you'll see a lot of times, they'll take screenshots of websites that are making particular claims. That's a very common tactic. They'll basically sketch out a violation, and often it's can be a very aggressive interpretation of existing rules, but they'll try to come up with a plausible violation. But then they will focus very heavily on companies they think are worth going after. And by that, I mean they have a lot of assets, or they have a lot of customers. And I'm sure the agency would justify this: well, the bigger the company, the more important the case. We're helping a lot of consumers. But I don't think it's a coincidence, and this is, again, just my opinion, that when the agency gets a very large money judgment against a company, there's always a press release. It says, we obtained $35 million. I mean, in the AMG Capital case, the FTC issued a press release. We got a $1.29 billion judgment against this company. Obviously, that is how they're promoting themselves with Congress and getting funding and becoming the agency it wants to be. I mean, they're really touting those kind of successes. And I think that's really motivating a lot of the attorneys that work at the FTC.
Let me drill down on a couple of aspects of this. My sense is 13B is used to go after what I would call small and mid-sized companies. Now, AMG Capital is obviously pretty big, at 1.29 billion. But has 13B been used to go after, Fortune 500 companies or some of the largest corporations in the world? My sense is it hasn't, or am I missing something here?
No, it really hasn't. And I think the largest target is a mid-sized company, but I mean that in that can be pretty big. I mean, $1.29 billion in the AMG Capital case. Remember, that represented all the money they'd ever made. That was their entire gross receipts for the lifetime of their company.
Right.
And there are a fair number of companies out there in that range. They might have $50 million in assets, $100 million in assets. And that is really the perfect target for the FTC. They tend to avoid the very large companies, though. And we can speculate about why, but a very, very large company is going to be able to put up a much more robust defense. And it's going to be able to raise a lot of the alarm about the process. which is something that a small, mid-sized company just can't do.
Wow. Do the courts, so a federal court judge receives this petition for 13B injunctive relief with disgorgement as well. First of all, the disgorgement funds, do those go to the US Treasury or do those go to the Federal Trade Commission?
So they go to the US Treasury. And so we can't exactly accuse the FTC directly of stealing the money, right? That's not what they're doing, but it goes to the Treasury. However, the disgorgement number, and there's the award number, and then there's what's actually paid, which are two different things. But traditionally, the FTC has reported those every year. They report those to Congress. And that is a huge part of how they justify their budget and their continued existence. We need X number of lawyers. We need X number of investigators. And this year we've acquired, $600 million paid to consumers and $30 billion in disgorgement to the Treasury. See how valuable we are. And that is how they convince Congress to fund them. And I think they also use it to try to expand their own authority. I mean, they have an active lobbying arm. They go to Congress, and they've been active since the AMG decision. They go to Congress and they say, we need this power back so we can get all this money and give it to the Treasury. I mean, I think it is a very transactional sort of argument.
Has the FTC or class action trial bar, has anyone sort of said, company A disgorged $500 million or whatever the number is. There are consumers who were harmed, and we want to figure out some way to return some or all of this money to the consumers and not to the US Treasury?
Well, what is, I think, particularly outrageous about this practice is after the 1970s, Congress actually took a very specific measure to say that the agency has very limited authority to provide redress to consumers. And it's called Section 19 of the Federal Trade Commission Act. It says in a proper case in federal court, upon proper proof, the agency can get direct redress, refunds paid to consumers. But courts interpreted that to mean exactly what it says. And they said, you have to prove harm to an individual, and we can order the company to pay back what they shouldn't have gotten back to that individual. That's it. It's no coincidence, I think, that the agency never used that authority. They said, we're not really interested in that. We want to do disgorgement to the Treasury instead.
So it's about enriching the US Treasury, not actually about getting any relief for any consumer, even if hypothetically there's a consumer that's harmed.
That has certainly been the practice.
Wow. When the Federal Trade Commission goes to a federal court, are there instances where under 13B, the judge says, I want to hear from an attorney for the other side, or does that just never happen?
It's very unlikely. It's very unusual. And typically the way the process works is the Federal Trade Commission will file a complaint in federal court, and they'll file it under seal, meaning that it's secret. And there's actually then a court order saying no one is allowed to divulge the existence of this case, certainly not to the defendants. They will then seek an ex parte injunction, and they'll file papers with the court saying, we think there might be a violation. Here's our evidence. And we want you to issue an asset freeze. We want you to stop the company from operating. And again, we don't want to tell them about it. The judge then will issue the order and appoint a receiver to take over the company. And at that point, in practice, that's when with a court order in hand, the receiver goes to the company, says, guess what? This is my company now. I'm going to run it. You've been sued by the FTC. And from that position, the company then has to try to fight back and say, wait a minute, we didn't do anything wrong. But at that point, they've already lost their company. They already have a court order against them. And they have to fight for their life. They have to prove their innocence, in essence.
Who are these receiver? How does the court appoint a receiver?
So the receiver is technically an arm of the court. They're seen as the court's representative to just protect the company and the company's assets while the litigation is happening. But again, as so many things that we're talking about, the practice is very different. The FTC recommends receivers to the judge as part of this ex parte process. And again, because the defendant doesn't even know about the case, they can't object. They can't say, we don't like that receiver. The agency just gives a list to the judge, and 99 times out of 100, the judge says, okay, I like this person, let's go with it. And how these people get on the list, that is an opaque process. And people have asked repeatedly since the 1990s for the guidelines, for some sort of rules for how the FTC is making these recommendations. And the agency has refused to say. They're actually, interestingly enough, in the 1990s, there was an an inspector general report about this process that had some conclusions, but that was sealed and is not a non-public report about how this process works.
Well, if the 13B complaint to the court is under seal, presumably the receiver doesn't know what the complaint is about either, does that person?
Well, so that is actually part of the process. And so what'll happen is the potential receiver is contacted. They'll say, do you want to be a receiver? They'll say yes. And then they become essentially a party to the case.
Okay.
So it's the FTC, the judge, and the receiver now can get together to decide what they're going to do to this other company and how the receiver is going to take it over.
And my understanding is the receiver can set her or his own fees for managing the company, and the courts can probably approve it. And so the receiver can say, I want some extraordinary sum of money every month for doing this. And
that's right. And I think it's also important to understand that many of these receivers are attorneys, and many of these receivers, in my experience, treat this essentially like a bankruptcy. What these receivers are supposed to do is they are supposed to run the company, keep it going, keep it earning money, keep it active while this case is going on, so that in the end, if there's a finding of liability, there will be assets, or they can fix the problems if there are, comply with orders, whatever. They're supposed to operate the business. A lot of times, though, the receivers treat this like, this business is done now, and I need to wind up its affairs, I need to liquidate its assets, and I'm not interested in really running it anymore. And so I think in practice, is because these cases take several years to litigate usually, what'll happen is the receiver will just wind down the company, liquidate their assets, and there's nothing left. The other thing I want to stress, because it's truly outrageous, is that the receiver is the emissary of the company. They're running it. If the company wants to spend money to defend itself on lawyers, the receiver has to approve it. So essentially, the company then has to ask permission to use its own money to try to defend itself.
Caleb, let me see if I'm understanding this. This sounds like something out of Kafka, but I don't think Kafka could have invented these circumstances. So there's an individual who has a company, unaware that they're doing anything wrong. There's a government agency that goes to a court and doesn't tell the court really much of anything and gets the court to approve to seize the company. there's a Supreme Court case saying this is unlawful, and the federal agency doesn't seem to care. The company gets taken from the individual and given to a third party who's going to collect a lot of money. Am I missing something here?
No. And I think I have had conversations with clients before who've explained this process to me. And I have a very vivid recollection of speaking to a client not that long ago who told me that he built a business for decades, and it was a very successful business. He felt that his life had really sort of reached its peak. And one day, a receiver showed up with federal law enforcement agencies and said, here's a court order. I am now in charge of your company. We've decided that a federal judge has decided you have violated a variety of laws. This is my company now. You all need to leave. And that person then, to defend himself, had to ask that same receiver for permission to access funds, to hire his own attorney, to try to fight back. And it is, in that situation, the only rational decision that he could make, that client of mine could make, is to settle with the FTC as soon as possible. And it's not because his company had done something wrong or had really violated the rules. It's that he had no options. It's the only chance he had to try to salvage something of the company that he had built.
And so, how do you go about negotiating with another party that has all the levers, and you're left with what negotiating power do you have at that point?
Well, you really don't. And if we think about it in terms of, I mean, let's say I am the company and I have legitimately done nothing wrong, but the FTC has maybe taken a very aggressive view of its rules, or it's maybe even relying on bad information. What can I hope to accomplish by proving that? Because at the end of all of this is we can go through the discovery process, we can do depositions, we can spend potentially millions of dollars on legal fees if the receiver will allow us to do that. And at the end of all of this, there's maybe summary judgment, and in very rare cases, there might be a trial where I can vindicate myself. And let's say I'm completely right, and I am guaranteed to win, and I do win. The reward at the end of all of that is they say, okay, fine, there wasn't a case anymore, you can have your company back. In the meantime, it's essentially been bled dry. The other option is, and it's not like you get the money back. They don't pay you damages or something for what's happening. The other option is you say, what can I do to make this go away now? How can I settle this? And I think in that situation, it makes perfect sense that people will sign just about anything, as long as there's a ray of hope. There's some chance to get their business back, or to get back to making money, to operating, to being successful.
Let me just go back to how these cases might initially be brought. So there can be complaints, maybe from consumers, maybe the company's done something wrong, but there can also just be complaints from competitors, from someone who has some grudge, personal grudge.
And the thing is, we don't really know. And so all we know, because the FTC, like a lot of agencies, is very sort of cagey about this. They say, we've received information.
Yeah.
You know, there's always the very sort of prominent use of passive voice. We've received information that this company is up to no good. And I do think a lot of it a lot of sort of what's concerning to me about all of this too is how subjective and unclear a lot of these rules are. Because part of the issue is the statute that the FTC is enforcing is an extremely broad authority. It says, well, you have to stop unfair business practices, but that's it. The statute doesn't really say this is unfair. So the agency has a tremendous amount of authority to decide, I don't like this practice, therefore it's unfair. And that in practice, I think is a very politicized process. As you know, Chair Khan has said a lot of statements about things that she just doesn't like. She doesn't like certain business practices. Ironically, one of the practices that she's been talking about lately a lot is it is about how you cancel subscriptions. And I use this because this is kind of a ridiculous example, but I don't know if you've ever tried to cancel your newspaper subscription to the Washington Post, the New York Times. Both of those companies, to cancel your subscription, you have to call them. You can sign up online, you have to call them to cancel. And they do that just to they'll try to talk you out of it.
Right.
But the chair has said that that is illegal. That is an unfair business practice. And one would expect that the agency, if they think that's really unlawful or unfair, would go after the New York Times or the Washington Post or certain cable companies. But instead, they've gone after a lot of mid-sized companies that have been doing the same thing that all these other companies have been doing for years, with no idea that somehow this violates the law.
Caleb, once a 13B complaint's been filed with the court and the court's appointed a receiver, does the FTC subsequently launch a formal and public investigation to actually see whether there was any wrongdoing here?
Well, and that I think is part of the egregious misuse of this process, because as I mentioned, the original vision for the process was the commission as a unified whole would engage in an investigation, go through an adversarial process, and make some sort of conclusion that it could then take to a federal court to enforce. When Congress set up this 13B injunction process, it's very clear that they also envisioned that the typical process would still be through the commission administratively, and this would only be a stopgap. They could get an injunction while they engaged in the traditional process with the commission. But that's not what they do. The agency never does that anymore. And it is extremely rare that the agency engages in any kind of administrative action or adversarial proceeding before the commission.
Do the commissioners, after the fact, ever review any of these? Or are these things are just completely beyond any review by anyone in any position of authority after the court issues the injunction and loss of funds?
No, they become a final decision, and what the Enforcement Bureau will do is they will rely on these settlements as precedent or as proof. And so what is a very common practice is the Enforcement Bureau will say to a particular company or even to a court, look, we think this particular business practice is unlawful, and you should know it too, because we had this settlement several years ago where a company was engaged in that same business practice. They settled with us. Therefore, it is now unlawful and everyone knows it, even though it went through this process that we talked about and it didn't go through the commission. And what is, I think, particularly outrageous about this process is on the rare occasions that the commission actually has to act or goes through an administrative enforcement, even when there's a settlement, there is a public comment period. That's required under the law. There has to be a public comment period. There can be dissenting statements from the commissioners. There's some sort of review. And actually, several months ago, the Pacific Legal Foundation, I filed a comment on one of these comment periods about a settlement that I believe violated the rules, and two of the commissioners dissented from the settlement. That process doesn't happen, though, in these court cases, in these 13B cases.
Well, this has been extraordinarily enlightening and extraordinarily troubling. Caleb Kruckenberg, thank you so much for being with us here today. I could continue this conversation, but I think I would only get more and more upset about it. That's probably not a good thing. I'm sure our viewers will follow this with great interest, and we look forward to having you back here at the Hudson Institute in the not too distant future to hear about updates and what's been happening with the FTC and the 13B. Thank you so much for being with us here today.
Thank you very much.